Hey, good morning. This is the clerk of the court, and it is 10 a.m. in Washington, D.C. Chief Judge Bartley, the conference is configured for oral argument this morning with recording and live video streaming now up and running. Counsel are prepared to argue, and all participants are ready to proceed.
Very good, Mr. Block. You may call the court.
The United States Court of Appeals for Veterans Claims is now in session. The Honorable Margaret Bartley presiding. God bless the United States and this honorable court.
Good morning, everyone. I'm Judge Bartley, and I'm joined today via video conference by Judge Greenberg and Judge Allen. And we're here today for the matter of Pat A. Hatfield versus Robert L. Wilkie, docket number 19-7165. Before us is the board's denial of DIC benefits under 38 U.S.C. 1151 and related issues of informed consent and not reasonably foreseeable issues. Counsel for the parties, please state your name and your appearance for the record, beginning with appellant's counsel.
Adam Luck for appellant Pat A. Hatfield.
Thank you, Mr. Luck. And the secretary?
James Drysdale for the secretary. With me is Jonathan Scruggs.
Thank you, Mr. Drysdale. As you know, each party will have 30 minutes to present their arguments. And Mr. Luck, I understand you want to reserve 10 minutes for rebuttal.
Yes, Your Honor.
Okay, very good. We will see that that happens. You may proceed when you're ready.
Thank you, Your Honor. Good morning, Chief Judge Bartley, Judge Allen, and Judge Greenberg, and may it please the court. Once again, my name is Adam Luck, and I represent the appellant, Ms. Hatfield, who I'm honored to have watching this proceeding remotely. This case involves a lengthy and complex procedural history involving the denial of DIC benefits under 38 U.S.C. 1151 for the cause of the veteran's death. As the court is aware, the veteran in this case is Ms. Hatfield's late husband, who received radiation therapy for his Hodgkin's lymphoma in 1978. He suffered an acute radiation reaction, which resulted in fatal radiation-induced pulmonary fibrosis. The veteran died approximately 7 weeks after his radiation therapy ended. There are two overarching issues in this case, which each independently support a reversal of the board's decision. The first is the board's misapplication of VA regulations when finding that the veteran's sudden death was foreseeable. And the second is the board's misapplication of VA regulations and this court's holding in McNair v. Shinseki when finding that informed consent was obtained. I'd like to address each of these issues in turn and then explain why reversal is warranted. Turning towards the first issue of foreseeability, the Federal Circuit held in Alice v. Shulkin that the foreseeability provision of 1151 requires that the VA care result in an unforeseeable event, and then that event proximately cause the disability or death. Ms. Hatfield doesn't dispute the Federal Circuit's holding in Alice. However, it was the Secretary's application of Alice that's incorrect in this case. The facts of Ms. Hatfield's case actually fall squarely within the holdings in Alice. The VA treatment was the administration of the radiation therapy. As a result of radiation, the veteran suffered an acute radiation reaction. That was the unforeseeable event which caused the quick onset fatal pulmonary fibrosis, which ultimately culminated in the veteran's death. Importantly, as the Federal Circuit noted in Alice, for an event to qualify as not reasonably foreseeable, it must be adjudged to have been not reasonably foreseeable at the time of the disability-causing event. Now here, the board made no such finding and in fact relied on multiple medical opinions that equally made no such finding or even made any finding of foreseeability as well. For example,
Mr. Luck, could I, this is Judge Allen, if I could just ask you a question about the, I'm going to call it the intersection of the two arguments, the consent argument and the not reasonably foreseeable argument. If the risk was of developing the condition because of the radiation therapy was one that was not reasonably foreseeable, right? That's the argument you're making. Why then would consent have been required if one couldn't have foreseen this happening? Do you see what I mean? In preparing for this, I noticed that those two arguments, there's a little bit of tension there. And I just wondered if you could address that.
Absolutely. And there is, as Ms. Hatfield recognizes, some tension, as you said, within those two arguments. But in this situation, there can be a situation where a veteran is treated without providing informed consent and nevertheless suffers an unforeseeable result of that treatment. And to address your question, it might be better explained in a hypothetical, in that a veteran undergoes treatment, and the only thing that's explained to the veteran is this is a common occurrence, we'll get you some treatment, and this ailment is resolved, no problem. Makes it sound like a routine procedure, call it a surgery. So the veteran in that situation didn't provide informed consent that complied with Section 1732. There's no discussion about alternatives. There's no discussion about what would happen if the procedure wasn't administered, complicating risk factors, foreseeable risk factors, who approved the consent, who verified the consent, the veteran wasn't given the opportunity to ask questions, so on and so forth. Yet nevertheless, the procedure is formed, the veteran suffers an unforeseeable event. So in that case, in that hypothetical, the veteran could have been treated without providing informed consent, yet nevertheless suffered an unforeseeable result. And here again, in this situation, Ms. Hatfield notes that the court doesn't need to find that the board erred in both finding a lack of informed consent and that the acute radiation reaction suffered was unforeseeable. Reversals warranted under either one of those two items.
And so as to any tension, Mr. Luck, your basic argument would be that these are two independent arguments that you're making.
Yes, Your Honor.
Thank you.
In turning towards foreseeability, as we previously mentioned, the board didn't make a finding as to what was foreseeable at the time VA treatment was administered. And it relied, there's 4 medical opinions, and it relied on 3 of them to make its foreseeability determination. The 1979 opinion didn't make any, or didn't render an opinion regarding foreseeability. It was asked whether the radiation dosage was appropriate, and it answered in the affirmative, and Ms. Hatfield does not dispute that. In passing, the examiner said pulmonary complications have a predictable and finite occurrence as much as 50%, but to any application to Mr. Hatfield's case, at best, that medical expert said this was very unusual. There was no opinion about what was foreseeable at the time VA treatment was administered. The 1980 opinion similarly made no opinion about what was foreseeable at the time the VA treatment was administered. And again, at best, in saying the likelihood of death that the veteran suffered in this case was less than 1%. The medical expert didn't make an opinion about whether a less than 1% likelihood would have been foreseeable, nor did he make an opinion about whether that would have been disclosed with any informed consent procedures. The court is aware that the board rejected the February 2018 private medical opinion that favored unforeseeability, and then the board actually relied on, found probative, the November 2018 VA medical opinion, which concluded that at the time of the VA treatment, acute radiation reaction as suffered by the veteran was an unexpected and unanticipated outcome of this procedure and would not likely have been disclosed on informed consent documentation. The expert took that a step further and said, even today, it is not likely that would have been disclosed when obtaining informed consent. And under 3.361, the VA is directed to consider whether an event is reasonably foreseeable in conjunction with the informed consent procedures under Section 1732. So in this situation, we have the only medical opinion that addresses what was reasonably foreseeable at the time the treatment was administered is actually favorable to Ms. Hatfield's case. Coincidentally, the board omitted any discussion of that portion of the VA examiner's opinion, and nor did it make any finding as to what would have been disclosed when obtaining informed consent under section 1732.
Mr. Luck, go
No,
ahead.
go ahead, Judge Allen.
I just wanted to get your view on something. It also seemed to me that the board's discussion about foreseeability sort of had aspects to it that carried over from what it discussed in terms of the consent. In other words, in applying the McNair rule, the board used the reasonable patient standard. But as I understand it, the foreseeability question is by regulation directed to the reasonable provider. What's your view about whether the board did in fact conflate those standards, and if it did, is that a prejudicial error to you?
The board did conflate those two items. You are correct, under the foreseeability provisions, that's what a reasonable provider would have foreseen at the time the treatment was administered. And that's why it's important, as we previously discussed, the board's erroneous reliance on those other 1979 and 1980 medical opinions, because they don't address what a reasonable provider would have foreseen at the time. Relying on a reasonable person would have been an error, because that, again, puts the medical providers, the VA treating facility at the jeopardy of the patient's hindsight. Nevertheless, in terms of determining what was reasonably foreseeable in conjunction with the informed consent requirements of section 1732, as what would have been disclosed when obtaining informed consent, the finding of whether 1732 was substantially complied with is not based on a reasonable person standard. It's based on all the evidence of record and takes into account veterans' statements, treatment records, expert opinions, etc. So to the extent that the reasonable provider applies in terms of foreseeability, there is also a second element as to what sort of disclosure was made under section 1732 to compare those two items. Does that answer your question?
Thank you. Yes.
Mr. Luck, I noticed, I'm going to walk you back just a little bit. I noticed that when you're referring to the event that you believe was not reasonably foreseeable, and also when you're referring to what needed to be covered under informed consent, you referred to the acute radiation pneumocystis, and you characterized that as the event or the outcome of this surgery. But wasn't it why aren't you referring to the fatal pneumocystis or fatal acute radiation sickness? Why aren't you including the death in there? Is there a legal reason why you're not wrapping the death and the fatality up with the pneumocystis?
Well, I'm doing that because of what the evidence suggests, the evidence that the board found to be probative. So the board noted that the November 2018 VA medical opinion was the probative opinion of record. And that opinion said, in this case, the veteran underwent radiation therapy, suffered an acute radiation reaction, which was an unanticipated and unexpected result. That resulted in the fatal pulmonary fibrosis that ultimately succumbed to the veteran's death. And that's echoed in the February 2018 private opinion that also noted the autopsy report said the veteran suffered an acute radiation reaction. So it's against the board's own reliance on that opinion characterizing that that unforeseeable event as the acute radiation reaction. Now, ultimately, this is a claim for the veteran's death and DIC benefits. But again, under ALIS, we're looking for what was the reasonable foreseeable event that ultimately caused that disability or death.
Thank you.
Counsel, this is Judge Greenberg. Can you hear me?
Yes, sir.
Is this the Alice case that I dissented in this court and which was reversed in part by the Federal Circuit? How many Alice cases do we have?
You were on the prior history. Yes, Your Honor.
Yeah. So how does this, so I'm familiar with the reasoning I applied in dissent in our court, which was adopted in part by the Federal Circuit. How does that apply here? How does the case apply to these facts?
The Alice case or your dissent, Your Honor?
Alice.
Well, the Alice case isn't directly on point. We're using the Alice for its analysis of the framework on what constitutes the unforeseeable event. So the facts, as you're aware, in Alice are a little bit different because it's a referral case.
Right.
So not directly on point, but the Fed Circuit in Alice did say, here's what is required to have a unforeseeable event, and then the proximate causation factor after that unforeseeable event. Does that answer your question?
I think so. All right. Go ahead.
So we spent a lot of time talking about foreseeability.
Were you, I think we might be on the same page. It looked like you were pivoting towards informed consent.
Yes, Your Honor.
Could I ask you just a sort of a predicate question on that then for me? Do you agree that there is a proximate cause element to informed consent? In other words, is your position that if there is no consent, right? I'm going to treat this as a no informed consent case, not a defective informed consent case like you had, for example, in McNair. Is your position that it's essentially a strict liability situation? If there's no consent, then, and it's a but-for cause, you know, an actual cause, that's it? Or do you have a proximate cause requirement for that as well?
So the plain language of 3.361 establishes the actual causation requirement and also the proximate causation requirement, but specifies that proximate causation can be established through a lack of informed consent.
Well, so that's actually what I'm talking about. You know, as we often say, this regulation is, you know, charitably stated, not a model of clarity, because when you have section D1, right, it starts out and it says you have to have you have to find proximate causation from that list of things, which doesn't include informed consent, right? It doesn't say those words, lack of informed consent, and you have to have actual cause. And then it says, and you have to find one of two other things, one of them being a lack of informed consent. But of course, that's strange to me because you had to have found a proximate cause for something in an informed consent case before you get to the and. Do you see what I mean?
I do, Your Honor.
For the life of me, I can't understand that. Because if in fact, in a pure informed consent case, because you're not talking this case about negligence, lack of skill, or anything like that, it's, I didn't get consent. If you follow the regulation in D1, you first do have to find something proximately caused the death. Assume you have to find that the lack of consent was proximate causation. Then you go to D1 little 2, and I don't understand what you would find there, because you've already decided that the lack of consent caused something. And now D little 2 says you have to find a lack of consent, but you've already found a lack of consent. Do you have an understanding of how that works?
I would say in this situation, when we're interpreting 3.361 and the proximate causation, the Federal Register notes that its reference to negligence, lack of proper skill, error in judgment, et cetera, is all essentially common law negligence. And common law negligence has consistently held that a lack of informed consent results in liability borne by the physician, borne by the provider not obtaining informed consent. I do think there...
Can I stop you there? Because I've looked at the common law as well, right? But in the common law, although the different states use different rules about whether the focus is on a provider versus the focus being on a reasonable patient, right? It uses different metrics, but implicit in using those tests, it seems to me, is a requirement of proximate causation, meaning there was no consent, and the failure of consent actually led to the death. Do you agree with that as a common law principle?
Mr. Luck, before you answer, Dawn, would you please add 5 minutes?
I certainly understand that question. I would say one of the issues in taking that position is the further requirements of Section 1732, which has the, as noted in McNair, has the materiality consideration underneath it, and that causation and materiality start to blend together under that consideration.
Let me cut right to the chase, right? I actually don't think the McNair rule applies in this situation. I'm going to be interested to hear Mr. Drysdale's argument, but it just doesn't fit for me with the language of the regulation, which says a minor deviation doesn't undercut a finding of consent, of informed consent. That made sense in McNair because there was an attempt to have consent and it was just defective, as opposed to here, the finding is the reverse, no informed consent. So I don't understand how that fits with the regulation. So I'm with you on that for now, subject to Mr. Drysdale's argument. However, we do have this evidence in the record that from the medical professionals that say, hey, listen, risk of death with no treatment was essentially certain, right? Under the common law, as I understand it, evidence like that could actually serve to break the proximate chain. So what I'm interested in is, do you agree that the regulation, even though it's not articulately said, requires proximate causation? Or do you say that the regulation actually is better read to say it's just strict liability? If there's no consent, that's it, you're done, as long as you do the but-for cause. That's why I'm interested in this.
I would say in this situation, I think the strict liability is the better reading. And the reason I say that is because looking at the history of not only Section 1732, but also 3.361, is the VA could have included language to establish and clarify the proximate causation element. Again, not a model of clarity, as you eloquently stated, but there's not limiting language establishing the proximate causation element either. And it had multiple opportunities to do so, but chose language to say proximate causation can be established by. And it's that language that may be regrettable to VA now, but it chose that language. And I think the plain reading is it's establishing strict liability because informed consent is so important. And under 38 U.S.C. 7331, formerly 4131, it's required that VA only provide treatment with the full and informed consent of the veteran. And I think that requirement is the foundation of 3.361 that ultimately says, obtain informed consent first, otherwise we could be liable. And I think reading it as a causation element, I certainly understand in this case, it's a very unique situation because of the fatality of the Hodgkin's lymphoma. But what differentiates this case in that situation is the speed at which the veteran died. And nobody prognosticated about how long the veteran would have lived had he not gone under treatment. We know there was treatment alternatives. He was scheduled for chemotherapy after his radiation. So there's a lot of unknowns from the fact pattern in this situation, but it is the speed at which the veteran died that is of importance in this situation that might distinguish it from, say, the veteran was going to die in 5 years anyways from this Hodgkin's lymphoma.
Thank you.
Continuing on,
Mr. Luck, first, Dawn, would you please add another 3 minutes? The secretary, Mr. Luck, pointed to one of Ms. Hatfield's statements about what her doctor told her about the radiation procedure being a 95% cure, you know, there was a 95% chance that it would cure him, points to that as evidence that there was an informed consent procedure here. The doctor was talking about risks. I assume that's what the secretary is alluding to here. What is your response to that as far as your argument that there was no consent procedure here?
A few items, Your Honor. One, the likelihood of success is not even one of the considerations under 1732. So any discussion about this is a 95% success rate of a cure really doesn't speak to informed consent. If anything, it might detract away from it because it doesn't include any foreseeable risk, how severe any complications of an unsuccessful radiation therapy might be, so on and so forth. And two, the board didn't rely on that to find informed consent. The board created its own alternative path to informed consent by doing away with the requirement of substantial compliance with section 1732 and saying that doesn't matter. Informed consent is not necessary as long as a reasonable person would have proceeded anyways. So to the extent that there is a statement of a discussion of a likelihood of success, I think that falls well short of not only consent, but informed consent, which is what's actually required in the situation.
Thank you.
And one last quick point, since I just got about a minute left, is regarding one of the board's errors. Is the board, there is some discussion about reasonable person and what a reasonable person would have done. But again, that reasonable person analysis established in McNair does not apply unless there is first that threshold finding that section 1732 has been substantially complied with. And again, I previously mentioned that whether section 1732 has been substantially complied with is not a reasonable person standard. And this court held in McNair that there's no presumption of regularity on what a reasonable or what a particular physician would have disclosed in a particular treatment to a particular patient. So the court in McNair actually remanded to consider the veteran's lay statements, the treatment records, and medical expert opinion evidence. You can see I'm out of time.
Yes, thank you, Mr. Luck. Mr. Drysdale, you may go ahead.
May it please the court. The court should affirm the board's decision because it correctly determined, in accordance with the court's holding in McNair, that informed consent may be established by either a document signed by the patient or by evidence that a reasonable person would have proceeded with treatment if risks had been disclosed. To show informed consent, as the board found, the evidence of record could contain a signed consent form. However, if it does not, and there's a lack of documentation, that does not itself prove a lack of informed consent. At that point, it becomes a factual determination a factual compliance determination as to whether the absence of that form is material. That's done by applying an objective reasonable person test based on a totality of the circumstances. As the court explained in McNair, if a reasonable person would have consented, then the lack of the signed form would be immaterial and the deviation would be minor, meaning that there was substantial compliance with Section 1732. The analysis is the objective reasonable person test is part and parcel of that materiality determination. It's not a separate and distinct analysis.
Mr. Drysdale, how does, this is Judge Allen, how does that fit in with the language of the regulation, right? Because the language of the regulation talks about not undercutting a finding of informed consent. I don't see anywhere in the board decision where the board found that there actually was informed consent. What it found, it seemed to me, was there was somehow by doing nothing, that was somehow a minor deviation. It seems to me that is a distinct, an important distinction from the situation in McNair, where there was an attempt at informed consent, but it was just generic. And so the court held, well, in this context, it was a minor deviation. And so basing a finding of consent on that could be okay. Do you see what I mean? It's hard for me to get having, just assume with me, no consent at all, and then we call it a minor deviation. That seems odd.
Well, it may or may not be a minor deviation. It's a factual finding to be adjudicated. And really, the key point that I would emphasize on that is that in either situation, McNair, where you have a generic form that doesn't disclose the specific risk that materialized, or where here you have no documentation of what was of a disclosure of the risk that materialized. In either case, a patient did not consent. There's no documentation that the patient consented to the risk that ultimately occurred. So in McNair, under that type of rubric, there's simply no material difference between what occurred in McNair and what occurred here, because in either case, the patient did not consent to, or there's no evidence that the patient consented to that specific risk. And so the veteran emphasized that, really the treatment has to be provided with full informed consent of the risks that could materialize. In McNair, you don't have that because it was a general statement and there was no consent to treatment for that, or no evidence that they consented to that specific risk. And here there's no documentation that the patient consented to the specific risk. So there's no difference. In either case, you don't have that signed documentation about that risk. And it's really, I would say, immaterial or perhaps irrelevant whether the veteran or the patient consented to some different risk that never materialized. How does that affect a determination on whether they would have proceeded had the risk that actually did materialize take place? And that's why that objective reasonable person test in McNair would apply equally here as it would in the situation where you have a generic form, because in either case, you have no documentation about consenting to that specific risk. And that is also consistent.
Mr. Drysdale, the statements that you're making right now, like, why do we even have an informed consent rule if it doesn't matter at all? And you seem to be conceding that there was no informed consent here, but going beyond that and just saying, well, it really could never matter.
Well, Your Honor, no, I did not say it doesn't matter, and I didn't say that concede that there was no informed consent here. I'm saying there's no documentation that the patient here, the veteran, consented to the specific risk. And so that may or may not be material. And that's determined by looking at whether he would have proceeded with the treatment had the risk been disclosed.
Yeah, and
So,
Mr. Luck pointed out the difficulty of that reasonable person test here, because Mr. Hatfield died right away, and if he hadn't had it, he seemingly might have lived for a longer period of time. Maybe, I mean, I think he said like it could have been a few years, and here he died within 2 months.
well, I would say the record rebuts that, it says otherwise. Really, record at 162, it's the November 2018 opinion, says that the veteran's lungs would have failed in relatively short order, absent the treatment. So there's no suggestion in the evidence to support Appellant's assertion that he could have lived for many years or whatever.
Drysdale, how long in days is a relatively short order?
I can't say that, but there is some.
Of course
Right.
you say that, and the board didn't say anything about this. You are literally making that up right now, right?
I'm not making it up. I'm citing the record.
Let me finish my sentence. You are making up the fact that the board thought about that at all, right? The chief judge's point is that if somebody says, if you have this treatment, if you don't have this treatment, you will die in X amount of time, right? That is different than if the point were you will die next week, right? And the board didn't say anything about that. And I know what you're referring to on 162, but there's no way to convert that into days or weeks or months, right?
Well, right, but the question to me was the appellant's counsel stated that he could have lived for years. So if it's not fair for me to say that it can be converted into days, he can't convert it into years. That's the only point. I'm sorry, I was just trying to point of fact in the record. There is some evidence that discusses that specific thing, and the board does cite that specifically on record at 14. So I wasn't trying to make a legal argument. I was just trying to clarify when I was asked, yes, that there is actually medical evidence that addresses that in the record. I was just making a point of fact.
Yeah, and can I clarify? I think that appellant's counsel, I'll speak for her here, was basically saying, look, someone tells you if you didn't have the treatment, you have 6 months or longer. And if you do have the treatment, you die within 2 months. I mean, what would you choose? You being a reasonable person, I am certain, Mr. Drysdale.
Well, yes, Your Honor, and that's what McNair discussed. They cited the Smith case from Nevada, where the risk of a minor irritant was compared to the risk of permanent vocal cord paralysis. So that's an adjudicatory issue of finding a fact. What would a reasonable person do in that situation? And that's based on a totality of the circumstances, totality of the evidence. What are the likely risks? How likely are they? And then the adjudicator looks at that to decide whether a reasonable person would have proceeded. And I think, as explained in McNair, that's really fair to the patient, to the claimant here, because in this case, you have the appellant, the veteran's wife, who's able to come in and make statements to explain what happened. But in cases that would result in death of a veteran, you may not have someone to come in, and then you have no idea what that subjective, what statements were made or how that was done. So the objective reasonable person test is the most fair to patients in that way too. And it is the rule that's applied in general tort law. It's a general tort principle, and 1151 is intended to incorporate general tort variety negligence, those principles. And so in general tort law, you have to show the duty, the breach, the injury, plus lack of informed consent theory, you have to show that satisfy that objective reasonable person test. Also, So McNair sort of tried to synthesize that and explain it. And if you look at general tort law principles and how they're typically applied, they do, vary by states, but overall, there's when this test is applied, you have to satisfy that in addition to showing there was a duty to get the consent. It wasn't documented, that there was a proximate cause, that it resulted in death or injury, and then also in addition that a reasonable person would not have proceeded. And so that's what 1151 is intended to incorporate, to restate those types of general tort law principles. And so, and that's, explained in McNair, and that's what is happening here. The lack of the documentation of the informed consent doesn't show that there was a lack of informed consent, because you still have to satisfy that reasonable person test to show the proximate causation.
Now, I'll pose to you a question that I posed a little differently to appellant's counsel, and that is you have this whole section of your brief where you're, I understand you're trying to kind of fit these facts into McNair, where we do have evidence that there was some kind of consent process. You're trying to fit it, but you have this whole section of your brief where you point out statements that Ms. Hatfield made about there being the doctor told her that the radiation would prove a 95% cure for most patients, I guess. And so you bring that up and basically point to that as evidence that there was some consent process here. Why isn't that just post hoc rationalization on your part? I mean, the board didn't refer to that at all.
Well, those statements are really immaterial, because you look at apply a reasonable objective person test, and that, here you have a patient who was facing certain death, 100% fatal if this condition was left untreated. And then you weigh that with treatment that had rare but potentially fatal side effects. What would a reasonable person in that case do? That's the test. I was also attempting to point out.
Mr. Drysdale, how can we apply that test here? You said rare but fatal side effects. We have absolutely no evidence in the record that that was what the veteran was told.
That's what the medical evidence shows, that is medically the case. So a reasonable, that's what it's a reasonable person. It's not the specific veteran. You don't need to have if you had documentation that this specific veteran had been told that specifically, then we wouldn't be talking about any of this, because you only get to the objective test if you don't have the documentation. I mean, if you have a signed consent form that discloses that specific risk, it's done. If you don't, then it's a factual issue to be adjudicated about what a reasonable person would do.
So the argument that you made in your brief that there was a consent process here, and you pointed, I know that you cited to these documents from Mrs.
I did,
Scott,
yes.
you're saying that is irrelevant.
Well, it's immaterial to the correct application of this. But I pointed that out because appellant's brief mischaracterizes, saying there's absolutely zero evidence that there was any attempt at obtaining informed consent, that there was no informed consent, and my point was that no, there's no evidence of the document. There's no documentation of the informed consent process. So I was just responding to the way appellant's counsel framed that issue in that argument. He emphasizes and repeats that there was no evidence of informed consent, but actually what we're talking about is that there's no documentation of the informed consent, but there may actually have been informed consent. We don't know for sure, but there's some suggestions in the record that there was. And then my legal argument based on McNair is that if you don't have the signed consent, then you apply the objective reasonable person test. So those lay statements are sort of immaterial to the proper application, but they are relevant to the arguments that appellant's counsel made in his brief.
This is Judge Greenberg. What's your view of the application or applicability of the Alice case to this matter we have here?
Right. Well, if I understand that, we're talking about the foreseeability issue here, and as I attempted to argue in the brief, the appellant's theory is really about the suddenness and the quickness of the death, that was unanticipated, and my point in the Secretary's brief was to argue that the pertinent issue is to look and see whether these pulmonary complications were a known risk of the treatment that was provided. And the medical opinion evidence uniformly states that these types of lung conditions are absolutely a known risk of the radiation treatment that the patient was provided. And then you look to see if that then resulted in death, whether that was foreseeable, and that did result in death. But the question is not whether radiation treatment could result in sudden death. The question is whether radiation treatment could result in these serious lung conditions that could be potentially fatal, and that is foreseeable as established by the medical opinion evidence in the record.
And the veteran was told all this?
There's no documentation in the record that the veteran was told this. So,
well, what do the doctors say they told him?
We don't have the documentation about what type of discussions were undertaken.
Why not? Isn't that reasonable to assume? Doctor says you should have this procedure, or this is the procedure that's available. You make a choice. Here are the percentages, or the likelihood of success, the likelihood you'll live longer, less long. Why didn't the doctor do that, or doctors?
Well, this gets a little bit to the point I was discussing with Chief Judge Bartley. There are suggestions in the record factually that those kinds of discussions did take place. The appellant has made those types of statements. But here we don't have documentation of the informed consent process that should have been in the record. So yes, there should have been a document that spelled this out, that was signed, that was put into the health record, and it's not there. And we the board acknowledges that. The question becomes, was that a material deviation from the informed consent requirements? The lack of documentation itself doesn't prove the lack of informed consent. And in McNair, the court cited the court's decision in Holcomb that you can't presume that you can't presume that the lack of the form means that there was a lack of informed consent. And then in McNair, you discusses how you go about determining that. The materiality determination, the substantial compliance determination is whether a reasonable person would have proceeded had the risk been disclosed. We know the risk wasn't, there's no documentation that the risk was disclosed. So we can't go back and ask the veteran at this point. So we have to look at what a reasonable person would do. And that is really the only workable standard for all the reasons cited in McNair. In many cases, a veteran who's deceased can't state what they were told. So, the alternative is a rule that type of strict liability. If there's no document, then the court would be presuming there was no informed consent, and that was the proximate cause of death, and that benefits have to be granted. And
what's wrong with that?
Well, Holcomb counsels against that. McNair counsels against that.
Yeah, but here we are.
1151 is intended to incorporate general tort principles, and general tort principles counsel against that. And the general evidentiary burden in benefits cases rest with the veteran. So if you don't have the signed document, it's a lack of evidence about informed consent. It's not substantive evidence showing that there was a lack of informed consent. It's simply you don't have the document. And so you have to look at what a reasonable person would have done. So, the general tort principles, the general evidentiary burden, the court's prior case law all suggest that this is still within the scope of the McNair type of test, because otherwise the lack of the consent form is dispositive. And that's contrary to all of those the framework, the general evidentiary burden, the tort principles, the court's case law. Yeah, I mean, it's the reasonable person test balances that and allows, based on the factual situation, a totality of the evidence and the circumstances to determine whether the reasonable person would have proceeded or not. And in this case, you have
excuse me, wouldn't the reasonable veteran have proceeded on the advice of a doctor in a white coat at a VA facility or otherwise, explaining this procedure is available and you ought to have it? Wouldn't a reasonable person rely on that rather than signing a form that says, I've been explained this, that, and the other thing, and I fully understand it, and I'm going to go through with it anyway? I mean, in the absence of such a form, couldn't we infer that the veteran believed it when the doctor said should have it, or it's available?
Again, we don't know exactly what this in particular veteran was told.
But why do we need that is what I'm saying.
Right, because there could be situations where it's a close call. In this case, you have a 100% fatal condition versus treatment that has rare but potentially fatal side effects. But in a much closer case, the doctor could say, we could treat your disease, but it may potentially result in paralysis, like the vocal cord example cited in McNair. In that case, the doctor's not saying this is what you need to do. It's a close call, and that goes to the patient. This case is an extreme example because it is a 100% fatal condition versus a treatment with rare but potentially fatal side effects. But in a close call, the doctor would say, you have these options. How do you want to proceed? A doctor doesn't say you have to do this treatment.
All right, I think I understand your position.
Mr. Drysdale, I just want to get to, I think that you need to show us that this falls under McNair, and I'm not sure you've done that. And I guess the way to do it is to show us that there was some informed consent procedure here. So you were referring to this document on, my page numbers are messed up. I think it's 1499, the 95, what I'll call the 95% cure document, which I'll be honest with you, does not convince me based on appellant's arguments and what he said informed consent normally includes, does not convince me that this was part of an informed consent procedure. But you also cite to another record document. I think it was in the earlier 1400s. What was said in that one is not the 95% document.
I would have to look specifically, but the veteran, appellant did state at some point that she and her husband did not agree to radiation treatment for it to, quote, burn him up. So if that's the statement you might be referencing, it does suggest that they agreed to radiation treatment, but they didn't really know the extent of the result.
We know that they agreed to radiation treatment because he had it done, and presumably they wouldn't have done it without him saying. The question is whether there was informed consent. Now, a statement that what were you saying? It said they disagreed on.
Well, they said they didn't agree to the treatment
that would burn him
to burn him up, I believe.
So that is the only other piece of evidence you're using to demonstrate that there was an consent procedure here. That something occurred, because we need something to have occurred for it to fall under McNair.
Well, yes, I mean, there are suggestions in the record that there were these types of discussions.
So
And those are from appellant statements.
right, and those are two. Was there another, was there something, there was a 95%, was the burn,
Yeah, I know there are multiple records where the appellant made this sort of 95% statement. She noted that in her substantive appeal at record 1540. She also made that statement in a document submitted at record 1499. So she referenced that sort of 95% in multiple documents. So there might be citations. I'm not sure what else.
okay.
I'm not aware of anything else.
Okay, and in response to appellant's counsel's argument that I think it was 17.32 does not reference survival rates at all, so that this, I think that was appellant's counsel's statement, so that is not demonstrative that a consent procedure occurred. What is your response to that?
I'm not sure I understand the question, Your Honor.
Appellant's counsel said that survival rates are not listed in 1732 as something that informed consent would cover.
Right.
So you are maintaining that this statement about 95% shows that some kind of informed consent, adequate informed consent procedure occurred.
Well, I would say that it discusses the risks of the procedure, the potential outcomes. It doesn't say that you have to disclose survival percentages specifically, but I think that is part of the risks of the procedures, saying that it would normally.
Could you stay on that point? Because I don't understand that at all. If I say something is 95% likely to be a good outcome, and that's all I know, the only conclusion we can draw from that is that there's a 5% chance that the outcome won't be good. But that says absolutely nothing about the fact that there could be a side effect, right? In other words, it could say you have a 95% chance that you won't have lymphoma. You got a 5% chance that it won't work and you still will, right? But if there were a risk out there that, for example, in this case, it looks to me like the radiation treatment actually worked with respect to the lymphoma, but yet he developed a complication. So it was successful, 95%, the lymphoma is gone, but he got a side effect, right? So I don't understand, especially without board findings on this, how we could possibly reach that result.
Well, because what this specific patient was told is not the relevant inquiry. It's a reasonable person in that type of circumstance.
No, but it is it is absolutely the as I understood the Chief Judge's question, and I agree with this principle if I'm understanding it. If there was no attempt at informed consent, I'm telling you, I don't think this comes within McNair. And so what this patient was told is absolutely critical for that, right?
Well, if I suppose if
Mr. Drysdale, let me just add a few. Don, would you please add 2 more minutes to the timer? And go ahead, Mr. Drysdale.
Right. So I can't speak to exactly what this specific patient was told, but in McNair, it wasn't about the consent form. It was about what whether a risk was disclosed, and whether there was a general form that didn't disclose the risk, or there was no form that didn't disclose the risk. In either situation, the risk was not, there's no evidence that the risk was disclosed to the patient and the patient consented to it. We don't have that documentation in either case. If a generic form doesn't show it, or there's no form that shows it's the same in either case. The risk that occurred was, there's no evidence in the record that it was disclosed. And when that's the case, then it becomes the reasonable person test. And since I've
Could I just ask you one question about that? And it's McNair. At least in part, I think in large part, McNair talks about deference to the secretary's position. So McNair said that this concept of minor deviation was ambiguous. So you have a regulatory ambiguity. And then the court deferred to the secretary and the secretary's interpretation. Do you agree with that generic rubric of how it went?
Yes, Your Honor.
Okay. What impact, if at all, is there that we now understand that from the Supreme Court's decision in Kaiser, that the extent to which courts defer to agencies is very different than what existed before under the Auer framework?
Right,
So,
Your Honor, yes.
Yeah, so what does that do to whether or not we still are bound to follow McNair?
Let's add 3 minutes.
So yes, Judge Allen. So the court in McNair did the analysis under looking at the text, the structure, the history, and so I would say that the analysis in McNair was solid and in accord with what was later sort of described in Kaiser. It wasn't just pure deference in a way of saying that the secretary has put this in a regulation and therefore we should defer to it. The court did actually undertake the exact type of analysis that should be taken, if a regulation is genuinely ambiguous under Kaiser. Chief Judge Castle, in authoring McNair, really did render an opinion that should stand up. The analysis has been done looking at the history, tax structure, et cetera. And, as we pointed out in our brief, Chief Judge Castle also authored the memorandum decision in Lancaster, which found that the lack of the consent form was not dispositive. So at least he was aware of McNair and the structure and how that worked and came to that conclusion. So, as my
I just saw Judge Allen disappear. Let's wait for a minute. Dawn, could you pause the timer as well? And see if we can get Judge Allen back on. Let's just hold off for now.
I apologize, my internet dropped off, but I am back.
Okay, let's resume. Mr. Drysdale.
So Judge Allen, I'm not sure if I, you heard the response to my question.
I heard
I mean,
you.
to your question.
I heard you say Judge Allen. And so
Okay.
I appreciate that. So maybe you can just give a quick summary for me, and I'll listen to the tape as well.
Okay. Yeah. So, Your Honor, Judge Allen, the in McNair, the Chief Judge Castle, who authored the opinion, did the analysis analyzing the text, structure, history of the regulation and how it is applied. So it wasn't purely deferential to VA. He didn't write that he had to do deference. He actually did an analysis that is now consistent with what would be required under Kaiser should the regulation be found to be truly ambiguous. So that the analysis should still be solid, and it is the precedential decision of the court, and it should be solid. And I also noted that even after McNair was authored, Chief Judge Castle, as we pointed out in our brief, authored the memorandum decision in Lancaster that also found that the lack of an informed consent document was not dispositive, that you still go to the objective reasonable person standard.
Okay, Mr. Drysdale, your time is out. Judge Greenberg or Judge Allen, do you have any further questions?
No.
It looks like we might have lost Judge Allen again. Let's wait until he is able to get back in.
Chief Judge, did you get the email says he should be able to rejoin in 2 minutes?
I see that email, and he sent one a minute later that said we should proceed without him. And so we will do so. He said he will listen to the argument. And since we only have rebuttal left, I think we can go ahead and just proceed since we have his okay. So, Mr. Drysdale, thank you very much for your argument. And Mr. Luck, you may proceed with rebuttal.
Thank you, Your Honor. A couple of points to quickly respond to right off the bat regarding informed consent. To take a step back and just to remind the court of what the board did, the board found that informed consent could be obtained one of two ways. One, through documentation of consent that complied with Section 1732, but the board acknowledged that there is no consent document of record. Then the board created the alternative path to informed consent, saying informed consent is not necessary as long as a reasonable person would have proceeded. But what this does is it renders meaningless the requirements of Section 1732. And as a policy matter, I would say encourages VA treatment providers to engage in less obtaining of this informed consent complying with Section 1732 as long as they can fall back on what a reasonable person would have done. The Secretary relates or focuses a lot on the documentation of informed consent, but what that really means is the lack of documentation really in this case is a lack of evidence of any consent. The board didn't describe or didn't cite to any other evidence that would support a finding of informed consent, let alone informed consent that substantially complied with Section 1732. So documentation aside, documentation it doesn't even go as far as to say, these are the recorded conversations, this is the evidence, here's what we informed the patient of, or any sort of other conversation that showed substantial compliance with Section 1732. And again, it is that substantial compliance with Section 1732 that is the prerequisite finding in order to engage in that minor and immaterial deviation analysis. Regarding the reasonable person standard, again, under Section 1732, there is no reasonable person standard. There's no reasoned physician standard. There's a totality of the circumstances and a case-by-case basis on whether Section 1732 was complied with, and that brings in lay statements, consideration of treatment records, so on and so forth. And that's important because, one, Ms. Hatfield enjoys the benefit of the doubt on any material issue in her case. And two, the board rejected her lay statements as being on complex medical issues, not as whether they spoke to substantial compliance with Section 1732. So in a situation where we have no evidence of consent and we get the benefit of the doubt when there's an equipoise of evidence, not only does the reasonable person not resolve that, but consideration must be given to all this other evidence. And speaking to the treatment records specifically, one of the experts noted that there's no expression of risk factors, concern of sudden death, acute radiation reaction expressed anywhere in the treatment records. And the treatment records actually no follow-up care with chemotherapy after the radiation therapy, which to me further indicates nobody expected this veteran to pass away so quickly. In regards to pivoting quickly over to foreseeability, again, those medical records also speak to what was reasonably foreseeable at the time of treatment. There is no expression of concern of any existing risk factors like smoking, previous infections, previous lung disease. The treatment was not experimental. His dosage was appropriate. There's just no evidence here that would indicate that anybody expected this outcome. So again, to remind the court, error doesn't have to be found on both items in order to reverse this case. And I do want to speak about reversal because we didn't get to it in the beginning. Ms. Hatfield asserts that reversal is warranted here on both issues. One, because the only reasonable reading of the evidence of record, which the board found to be probative, shows that acute radiation reaction was not a foreseeable event. And the veteran's death, as the board found, was caused by VA treatment. So we have the actual causation, and we have the only medical record that the board found to be probative that actually speaks to what was foreseeable at the time of the VA treatment, concludes acute radiation reaction was an unexpected and unanticipated result, would not have been disclosed when obtaining informed consent, and was not expected at the time of treatment. They took that a step farther again to say, even now, it would have been disclosed as a known risk. Regarding informed consent, reversal here is warranted again because the board made no finding, nor does the evidence reflect substantial compliance with Section 1732. And one evidentiary matter here is Ms. Hatfield recognizes that an absence of evidence is not necessarily negative evidence. But as the court noted in Horn, to establish that absence of evidence reliance, that foundation, consideration must be given to whether the factual predicate would have been included in the record cited to where the absence of such exists. So in this case, under Section 1732 and previously Section 1734, there should have been some sort of documentation, whether it was the notation of a discussion, an informed consent document. There should have been some sort of evidence that established informed consent was obtained. That is not present in this case. Without any evidence of informed consent or substantial compliance with Section 1732, there cannot be a finding that informed consent was obtained to bring in the McNair reasonable person standard. And one quick point on reversal. This case involves 10 board decisions. That means the board has looked at the record 10 times and still found no evidence of any documentation of any consent. It is unlikely that a further remand, the board's going to magically unearth evidence of informed consent or even evidence of substantial compliance with Section 1732. Again, Ms. Hatfield acknowledges she's required to show evidence in support of her claim, and she has done just that. She's provided statements that the treatment was administered without informed consent and that his acute radiation reaction resulting in his death was an unforeseeable outcome. There are treatment records, medical opinions of record, and it is the VA's burden under this court's holding in Gilbert and under Section 5107B to show that there's a preponderance of the evidence against this case, and the board simply has not done that. The only way it could find to deny Ms. Hatfield's claim under an informed consent theory was to create a new avenue to obtain and establish informed consent, an avenue that does not exist and is not supported by the regulations. Regarding foreseeability, again, as mentioned in briefing, the board relied on 2 medical opinions from 1979 and 1980 that are inadequate. And the opinion that it gave probative weight supported that the acute radiation reaction was unforeseeable at the time of the treatment. So by the board's own admission, the probative weight establishes informed consent. So in this case, again, there are 10 board decisions, but there are there's one plausible reading, and that supports a reversal on either issue. With that, that's all I have, Your Honors.
Thank you, Mr. Luck. And thanks to both of you for your arguments. The case is submitted for consideration.
And the court is in recess.